Hi, my name's John Hall and I head up the Personal Injury and Medical Negligence Department. I specifically specialise in medical negligence claims and have been recovering compensation for clients in relation to claims where clinical procedures have gone wrong due to a doctor's error. Well, examples of medical negligence can be where a GP has failed to diagnose the client's condition such that the client has gone on to suffer injury which shouldn't have occurred. Or it can mean where a client has been admitted to hospital and undergone surgery and the surgery has gone wrong so that they've been left with an adverse result at the end of the day. There is a time limit of 3 years which starts running from the date on which the procedure went wrong. However, in certain circumstances where you're not aware at the time that there has been any negligence, time will run 3 years from the date on which you ought to have been aware that something has gone wrong. When a client calls us in connection with a claim, I will take a brief summary of what happened. I will then apply to the client's GP and the hospital involved for copies of the medical records. I will then screen the records to determine whether or not I consider there is a viable claim. I deal with a wide variety of claims, both from low value to very high value. In fact, my own specialism is in the high value claims, and I deal with a lot of birth injury claims where a child has been born deprived of oxygen at birth and has suffered severe brain injury. We initially screen cases free of charge for clients. So when a client has a problem, they will contact me and I will be able to check their history, the medical records and notes, and make an assessment of the prospects of successfully pursuing a claim. If I consider that a client has good prospects of success, then I will discuss funding. Effectively, there is no legal aid available to clients in relation to clinical negligence claims apart from very limited circumstances. So I will ask a client if they have any legal expenses cover. Again, most clients probably won't have such cover, so the normal arrangement would be a no-win, no-fee arrangement. Now, effectively, what that means is if I consider that the client has a viable claim, I will take on the claim, and if the claim is lost, there is no charge to the client. The level of compensation really depends on the type of injury, but you would be entitled to recover compensation for the pain, suffering and loss of amenity involved as a result of the claim. In addition, you would be able to claim any loss of earnings or out-of-pocket expenses. In higher value claims, you may be able to claim for the cost of a care regime. So I deal with cases where 24-hour care is required. So we receive compensation for the care regime, for case managing it, and for all the consequence expenses involved. My advice to you, if you think you have a claim, is to contact me immediately and I will arrange either to see you myself or for a member of our team to see you to take detailed instructions to see whether or not we consider the claim as viable.